Good morning everybody, Namaskar, Sat Sri Akal and Adab. This is my 214th video and it is in continuation to the consultation which is required and to be taken by residents of these cantonments through me if they want so. So how do we begin? I just taught in my earlier video, I told you about the Janam Patri and its expenses, and that is our first step. So how do we move now? This is in continuation, step 2 basically, and this is, let's say the bungalow owner or the resident has been issued a notice under either of the sections which I told him, which I may repeat for him again. If it is notice, it is issued under the Cantonment Act 2006, or it is issued under CLA rules in 1937, but which will not be. Now all notices will come under the 2020 CLA rules. This notice finally either the bungalow owner or the resident would go into the court. So here the notice gets into judicial acumen. So you become the plaintiff and the department is now to prove. There is a modus operandi in some cases where the department has, instead of issuing you notice, would go in for a recovery notice. Let's say you've done unauthorized construction, they'll fine you 5,000, 10,000, 50,000, they will file a suit in the courts. Now you approach the court, either you accept the fine and admit that yes, you've done unauthorized. Now whether that has to be broken on the second day or the third day, whether you connive with the department and you save it out, that's one issue. You get a 244 notice like in Landor it was issued. Most of the people accepted the fine there of doing commercial activities. Now forever they are standing under the regime that they have committed an offense. Most of the advocates in Landor at that time, no, Mr. Das, let's accept it, let's accept the fine and finish off this case instead of fighting it. Then finally, if you fight, let's say if you reply back to the notice and you do not go to the court, the department is bound to take you under PP Act. So I explained you 3.1, 4.1, 5.1, 5.1a, 5b1 and then 5c1 and 7 other notices which the department under PP Act would issue. So how do we begin now? So the beginning is that if the bungalow owner has not got his Janam Patri or resident made, his first step would remain that only, that he will come back with all the documents, pay me out 20,000 rupees. If any other additional expenses of vernacular records of translation, typing or photocopying would be paid. Once this is done, we move to the conference. So we have a Zoom meeting, we plan our course of action, and we move to the next step. So the next step is very crucial here. Now till I do not know your records, there are the 3 pillars of the system of the constitution. The pillars are very clear. It is the executive, it is the judiciary and it is the legislative. So where can an Indian or a citizen of India move? He can either take his fight to the executives. Executive has a subsidiary to it, that the same executive is given a right of an estate officer. Now what is an estate officer? An estate officer is an officer who by his own notice is also the court of his estate. Now let's say the defense estate officer or even the cantonment executive officer. Under the Government of India's delegation power and the notification of PP Act, they carry these power. You will be surprised, even the station commander of your cantonment has the power of a state officer being. Sometimes he would initiate a PP Act on you. So you cannot say he is debarred from doing that. He can. I came across a case on some cantonment where the station commander was taking the initiative minus the cantonment executive officer. So this is where we will discuss our course of action. Every bungalow owner resident will have to take a Zoom meeting with me without this step of Zoom meeting or a video audio call on WhatsApp or Telegram, any mediator of this net facility could be used. We will chalk down our action plan. And the most important part in all this is that bungalow owner will approve these plans, and once this approval is there will be signed agreements. A special power of attorney will flow into me, where I'll be entitled to make decisions then, deciding on the course of action what we've decided. Nothing outside that bound. But I need powers to appoint legal acumens, to make sure that what I'm signing and writing to the executives. So here this step second will have subsidiary steps, and this step once is approved, what are we doing? Are we running to the court and asking for a stay? Provided we get it, we don't get it, we move to the High Court. These are multiple questions. Or we are taking an executive fight on this notice. So this is very important for everybody. So this second step is crucial. Once we decide this, then my consultation will begin with my fellow residents. And believe me, I am first a bungalow owner, a resident myself, then I am somebody other than on your platter. That is why, friends, I did not take my advocate license, because once I do this, I will not be able to make my YouTubes. I will become an advocate. Today, after this second step, believe me, I will give you a 99% assurance of what I am going to deliver to you. So I think we understand this now. So the second step of either executive war or the judicial war would be decided. So this is very crucial and important. So friends, thank you. Good day.